Okay, welcome to the beginning of my final week of this part of the estate and tax planning course. So from next week onwards, Lynn May Tan will be taking you through the tax part, which should be fun. Today we are looking at our final topic, which is the Property Relationships Act, otherwise just the PRA or relationship property. So there's quite a bit to cover here, and it can get quite complicated, although the general principles are straightforward, as you will see. The devil is often in the detail, and that is usually because, human relationships, by their very virtue, can get quite messy, and there's a wide diversity of that, and there's just a wide diversity of aspirations and the kinds of property that people have. And the way that we enter relationships these days is quite different. And so that's one of the reasons that the Law Commission has proposed quite substantial changes to parts of the property relationships regime, but to take into account the fact that it's increasingly rare for parties to sort of marry in their mid-20s, buy a house and then stay together until death or divorce in their 50s and 60s, and that's the only relationship they have. There are increasingly sort of situations where it's usual that people will have more than one significant relationship in their lives, and that means that the kinds of property that they're bringing in, and also the dynamics of their relationship and the expectations of children, etc., also need to be taken into account, which makes everything really interesting, but does add quite a bit of complexity, even with the Law Commission's proposals, which to some extent were placed on hold. And we'll get to this in the next session, because they were also waiting to find out what they were going to recommend for their review of succession law, which we touched on in topic 2. No, topic 3 is topic 2. Topic 3, the second topic we had on. Anyway, so in this session, we're going to cover the basics, which is the basic policy theories and principles underpinning the Property Relationships Act, henceforth the PRA. We're going to look at definitions, and the two biggest and most important definitions are to look at the kinds of relationships that it covers, and those are marriages, civil unions, and de facto relationships, and also this concept of relationships of short duration. We are going to look at property, what is relationship property and debt, what is separate property and debt, and particularly what is the family home and family chattels. We're going to very briefly look at relationship property entitlements upon separation and death. We'll look a bit more about death next session. And next session, we're going to do the more fun stuff, I think. We'll look at contracting out and separation agreements. As indicated in the notes, while the entire part 6 is called contracting out, the types of agreements you'll enter into at the beginning or during a relationship are more commonly called contracting out agreements, and then they're quite different in the content to the types of agreements you'll enter into at the end of the relationship, which sort of set out, who's taking what. We'll look at exceptions to equal sharing, the powers of the court, and some of those Law Commission recommendations relating to relationship property generally, and division upon death. If we have time, we will look at maybe some basic sort of calculations, because I know you, for the most part, you'll be quite your numbers people, and a lot of this calculations, including when you're looking at separation agreements and division of relationship upon death, includes spreadsheets calculating, defining what is and is not relationship property and separate property and debt, and then sort of adding it all together and finding, who has what and whether or not, particularly for separation, someone needs to get a payment to balance it out, etc. It's kind of fun. Those are the topic outcomes. Again, we're looking at just I suppose the key thing is to understand the PRA and its implications in the context of this asset and tax planning. So we're not trying to make you into relationship property lawyers, and having worked under the supervision of a very sort of capable relationship property lawyer who had been in the sort of business for decades, really, it would be impossible to do so, because even she would say that she was constantly learning. And appreciate, what relationship and separate property is, and identify the differing rules that apply, and the significance of contracting out agreements. We won't be looking at the tax implications of those transfers, but that will be coming up in the later topics covered by Lynn May Tan. Okay. So I'm using as a guide in terms of the structure of the discussion here, that chapter 3 reading from the issues paper looking at the division of the relationship property law that was published by the Law Commission. So that was a report that was setting out the existing law and the issues with it, and then raising some questions for response so that anyone could provide their suggestions about what worked, what didn't work, what changes should happen. And chapter 3 of that sets out in a summary of what the law is. And I think it's a really good summary, and in particular because it was written by experts in the field. And sometimes with this legislation, we can get a little lost in the weeds of some of those definitions, as you'll see. So it's important just to start, I think, with understanding what's underpinning this and what the law is trying to achieve. And what the law is trying to achieve is a just division of relationship property at the end of the relationship. And that question is, therefore, what is a just division? And if you ask different people, they will potentially give you different answers. And that may be very much tailored to, the circumstances of each relationship. And they talk about this theory about, a qualifying relationship. So if you're married or in a civil union or a long-term de facto relationship, you and your partner are equal partners, you're a joint venture. And so therefore, the division of relationship property should reflect the fact that you are in this joint venture. But in that certain circumstances, it may be appropriate to depart from that 50-50 split when there's some issues regarding economic disadvantage suffered due to the relationship, and when the needs of the partner or children require it. So this departure on economic disadvantage grounds we'll look at it a bit more in a bit more detail next session. But again, it's something where actuaries are now required, because there's a very famous case called Scott and Williams that set out how how lawyers, etc., should calculate whether or not there is an economic disadvantage between the parties and how to therefore sort of compensate for that. But the rules are very complicated, and it's still subject to a lot of dispute. So the law sets out, or the Act sets out, a number of what the Law Commission call explicit principles. And some of the majority of these principles were written before the marriage equality legislation came into force. And so that way, for that reason, there's a lot of sort of gendered assumptions in some of these principles, although the Act does apply to all relationships, as we will see, regardless of sex or gender status. But the explicit principles of men and women have equal status and their equality should be maintained and enhanced. That all forms of contribution to the marriage partnership or relationship are treated as equal. That's really important because contribution is defined really widely by the Act, and that includes contributions to maintaining the home. So it's those moral sort of support, it's those practical things. Previously, the argument has been contribution has to be purely economic, but the work, that emotional load in maintaining the relationship can be just as important, often more important. And at its very most basic, in a traditional relationship, the work in looking after and raising children, which according to gender sort of roles has often been left to women, that contribution needs to be recognised. And that is why they consider that a just division of relationship property has regard to the economic advantages or disadvantages to partners arising from the relationship. So traditionally, and it's still the case, the situation would be, and this is a general rule, so there's always exceptions to the rule, and they can be quite significant exceptions, but the general rule is that even when the Property Relationships Act rules of equal sharing are applied, that men will leave a relationship generally in a better financial position than women. And this will often be just as much because women will have often taken a break from the relationship, from work in order to raise children, etc. And as well as the control of networks, different kinds of property, etc. Also because the work that women will often do will be paid less because of those pay equity situations. So they may have less in their KiwiSaver, etc., even if that is divided equally. And then they will be starting at a lower wage or returning to the workforce or continuing in the workforce often at a lower pay than their male counterparts. Again, very general rule, but this is some of the stuff that's underpinning the legislation. And that questions arising under the PRA about relationship property should be resolved as inexpensively, simply and speedily as is consistent with justice. Yes, so there's a presumption in all family court proceedings, particularly those family court proceedings relating to children, that lawyers actually have an obligation to recommend that parties sort of use alternative dispute resolution like mediation, etc., rather than go to court, because the court is expensive. And even if you are going to the family court is so busy and overburdened, and often these relationship property cases are so complex and they're not necessarily treated with the same degree of urgency as, for example, things like protection orders and family violence. So, which makes sense, but that does mean this inexpensively, simply and speedily can be done if the parties are, for example, agreeing to a settlement between themselves. But if you need to go to court or get some assistance to sort things out, often it's not as inexpensive or simple as you would hope. Does anyone have any questions or comments so far? No. So we won't go through these line by line, but in addition to the explicit principles, the Law Commission identified a number of implicit principles. So one of the more interesting ones is that the law should apply equally to all relationships that are substantively the same. So there needs to be a degree of consistency of treatment of relationships, and that helps people sort of predict how and better understand how their own relationship will be treated under these rules. But it also means that even if they may be unhappy with how the rules apply, if they sort of are able to accept, or this is the hope, if they're able to accept that all the principles have been applied, to everyone else in the same way, then there's a concept of fairness and justice to that. We'll look at this issue regarding misconduct, but misconduct during the relationship is generally irrelevant to the division of property. And what that means is, just like in New Zealand's divorce, there is a no-fault divorce system. So all you require in order to dissolve your marriage is 2 years separation. That's it. There's no quick way through it. And you cannot divorce anyone on the grounds of adultery or poor treatment, etc. The same more or less applies here in the division of relationship property. So you can't argue that you should have a greater share of the relationship property because because of the other party's infidelity, or even general family violence, I'm afraid to say. There can depart from some of the equal sharing along some of the rules, where one example that we had was where a partner was using relationship property for his substantial gambling habit, and that was a few $100,000 had disappeared into his gambling habit, so that needed to be taken into account when dividing the remaining relationship property. And also they had family trusts, so interest in the family trusts there. Okay, just to guide you through it, we won't look at this again, but as with all pieces of legislation, they are sort of split up into parts, particularly longer pieces of legislation are split up into parts, and those parts sort of set out, relate to different aspects of the operation of the Act. So as you can see, we're going to be looking for the most part here at part 2 to part 4. We'll look a bit at part 5, 6, and 8 next session. Okay. So until recently, as you may be aware, or until the marriage equality legislation, the Marriage Act set out what the definition of marriage was, and that was a man or a woman. There was a very famous case called Quilter, and in that a lesbian couple sought to have the courts interpret the Marriage Act in such a way as that it would allow gay couples to marry. The court found that they were unable to find a natural interpretation of the legislation which would allow that, and sent it back to Parliament. The initial response of Parliament was the Civil Unions Bill, which we will look at, which was seen as a middle ground because there were some vested interests that still saw marriage as something that had to be particular to men and women, and that was often coming from, as you may expect, sort of more conservative religious groups. But now we have the situation where marriage means the union of two people, regardless of their sex, sexual orientation, or gender identity. Just as a note, marriage includes a marriage that is void. That could be void by reason, for example, bigamy, or if the celebrant doesn't follow all the rules, or you think you're getting married in front of a celebrant who turns out not to have been registered or licensed, then your marriage would, for the purposes of this Act, still be considered to be legal. So your division of relationship property would be in accordance with the rules relating to marriage and not de facto relationships. And you will see there that it also applies to marriages that is ended while both spouses are alive by a legal process that occurs within or outside New Zealand. Why that is relevant is, for example, as we'll look in terms of movable and immovable property, and whether or not their legislation allows for the division of, in that other country, would allow for the division of immovable property in New Zealand. So arguably speaking, even if people are married and then they're divorced in a foreign country if they own a movable property, which is land in New Zealand, and then the division of that land is governed by the Property Relationships Act. In terms of taking into consideration the actual length of the marriage, as we'll see, that becomes quite significant. You will be looking at the period before, like if you were in a de facto relationship, living together in that relationship for 2 years, and then you are married, and then you are married for another 2 years before you separate or before one partner dies, then you're considered to have been married for 4 years. Which makes sense because it was the intention of the parties by marrying to, well, it's read by the court, to therefore come under the rules relating to marriage under the Property Relationships Act. Civil unions basically have the same provisions there. Yeah, there aren't that many civil unions these days. I think there's still a few, but I think to some extent it was whether or not you could get, have legal recognition of your relationship without necessarily bringing with it some of that emotional baggage that some people associated marriage or the concept of marriage with. Okay, so de facto relationships. De facto is to be opposed to de jure. So de jure is in law, so a relationship in law, and de facto relationships are a relationship in fact. You may or may not be aware that New Zealand's inclusion of de facto relationships under the relationship property legislation from 2001 is somewhat unique to particularly common law countries. So not all common law countries will, in which you are living together in a relationship in the nature of marriage, will provide you with the same or nearly equivalent entitlements to the division of relationship property. So in terms of de facto relationships, you need to be both aged 18 years or older. That can be quite significant. For example, if you have young people who, childhood sweethearts, etc., who may actually move in and live together at a younger age than that, and whether or not that period of time is going to the period of time that they are living together up until the age of 18 is generally not going to be considered part of the duration of a relationship, and will also potentially not be considered for things like the acquisition of property or not. So you may or may not be aware that this determining whether or not a de facto relationship exists is not always as straightforward as it may seem. And so it's not just whether or not, the simple, situation is you've got two people who live together in the same house, they have a sexual relationship, and they maybe share a joint bank account, and they have, a cat and a dog and maybe a child or two. And nice and easy, looks to the outside world and within the relationship, it is de facto. The difference becomes, for example, when you may have very long-term relationships where the parties may live at a distance and, for example, visit each other. Whether or not that becomes a de facto relationship can be a question on the facts. Questions as to whether or not relationships in which parties are sort of emotionally but not sexually intimate, and whether or not they can therefore be considered to be a de facto relationship. All of these things come into consideration. How do you determine the difference between, for example, two flatmates who share the same flat for a number of years, particularly in this sort of era where, you know, purchasing a house can be really difficult, and occasionally may sleep together and share a bank account for flat expenses, how do you distinguish between that and a true de facto relationship? And it can very much be a question of fact. And so the court isn't required. So I was just looking, does anyone have any questions or comments?
Yeah, sorry, just quickly.
Yeah.
I know essentially because of something that happened in my own relationships is that sometimes other bodies seem to make a decision about whether people are in a relationship or not. So you know, as an opinion and stuff. Does that have any bearing on those, or would the court potentially consider that sort of thing?
The court would definitely consider that kind of thing. If you're talking about things like work and income, yes. And there is some, I need to go back and sort of check, there was some quite famous case law about how work and income were considering whether or not someone was in a relationship in the nature of marriage. I believe the case was called Rooker, and it was a situation in which there was significant domestic violence and someone was not able to necessarily get free, and yet the work and income considered to still be in a relationship in the nature of marriage and therefore cut her benefit. And I think also chased her down for receiving a benefit, you know, overpayment, etc. They were supposed to tidy up their act a bit, but yeah, there are some significant issues there. And I know that among welfare agencies, generally they have encouraged or advocated for a change in that legislation and those policies. Yeah, so it would be taken into consideration. I'd say the WINS test is actually lower, unfortunately, than the courts.
Oh, definitely agree. Yeah.
Yeah. So the court is entitled to have regard to such matters and to attach such weight to any matter as may seem appropriate to the court in the circumstances of the case. And I can't remember the case name right now, but there is a case referred to in your materials where the parties had talked about and, you know, were very close, but then got to the point where they were planning a marriage, etc. But the courts did not consider that a de facto relationship existed, because even though there was an intention to enter a marriage, there wasn't an actual de facto relationship at the time that everything broke down. There has been a few famous cases where, particularly after the death of someone, people have claimed that they weren't just someone's housekeeper, that they actually had a sexual relationship with a particular person and therefore should be able to share in that relationship, so share in the relationship property. And that can be quite difficult because, you know, what goes on behind closed doors and how people sort of share their property can be quite different to, you know, the reality out, you know, of what people perceive out in public. So yeah. So relationships of short duration. So for all relationships, a relationship of short duration is a period of less than 3 years, but it's a period of 3 years or longer if the court considers it just. Now, marriage and civil unions is really easy unless there's a de facto relationship before it. You just say it's the date of the marriage. Figuring out the date that a de facto relationship started can actually be quite difficult. You know, is it the date that someone suggests that you move in? Is it the date you actually moved in? Or is it the date that you all went to a friend's dinner party and introduced, you know, said, we are now, you know, a couple with a capital C, etc. Also as difficult sometimes is the date of separation. And this is the case for all relationships, figuring out when exactly you're separated, particularly if you've got, you know, you're having arguments with each other, you know, things are slowly dissolving. One party, of course, can unilaterally end the relationship, and yet then the other party may not wish to agree to that. With marriage, that doesn't stop a divorce, but it can mean that the process just becomes a little bit more difficult. There's just more paperwork involved. But yeah, so those two dates can be difficult to figure out sometimes, which aside from anything else, when we're looking at some of those contracting out agreements that we're going to look at, that can be the value of them aside from anything else. It can be to state, this is when we agree the relationship began. Because often those contracting out agreements will provide for some relationship property, and having that start date can be quite good. And sometimes, yeah, again, getting a lawyer involved and having a lawyer send a letter when you separate and say, we are now separated, or having something like very formal can be helpful at some point in time to actually determine the end of the relationship. The Act does distinguish between marriages and civil unions of short duration, and de facto relationships of short duration, as we'll see. For a de facto relationship of short duration, you also need to have a child of the relationship. That doesn't necessarily mean that that the two parties must have a biological child together or adopt a child together. It could be if one party has a child from a previous relationship, and then the de facto partners get together and that child is, raised effectively by the other party as a stepmother or stepfather. There could, in some circumstances, that be considered then a child of the relationship. Or there's a substantial contribution to the relationship. And then you also need to prove serious injustice. So the general rule is that if you're just a standard de facto relationship without children of less than 3 years, then your division is going to be on standard grounds. You're just going to take out what you brought in to some extent. So if you don't have a qualifying relationship, for example, you are a relationship, you're sort of like partners, but you're not de facto partners, then there's a presumption against equal division unless you can show agreement otherwise or a constructive trust. So essentially, you may recall we were looking at how before the Matrimonial Property Act, which was the original name of the Property Relationships Act, that the law relied upon finding a constructive trust for the wife when a husband held, the family home in his name. That kind of legislation will still, not legislation, but that kind of law will still apply, and those principles will still apply if your relationship is not covered by the Property Relationships Act and you break up. And depending upon the value and nature of the property, if you're sort of flatmates who slept together, then you might be arguing in the disputes tribunal. If it's, bigger, more substantial property, you might even be heading through to the High Court. Then this is where it starts to get sort of interesting. Is if you have a marriage or civil union of short duration and then you separate, then the division is according to contributions. But if you have a marriage or civil union and then one partner dies, there's a presumption that you're entitled to equal division of the property unless that would be unjust. And we're going to look at how that works in relationship to sort of entitlements under will or intestacy in the next session. If there's a de facto relationship, however, again, you only get to divide according to contributions if there's a child or substantial contributions and there's serious injustice. Otherwise, you're not covered by the legislation. And yeah, if you get, and then death is the same provision for de facto relationships as well. So this is where there is actually a significant difference between how the legislation, the law generally treats married couples versus de facto couples. But once you reach over that magical 3-year period for all relationships, then they're all treated more or less the same. And it's equal division unless an exception applies. Any questions? Okay, assuming not. So going back to our topic 4, where we looked at property and definitions of property and real property versus personal property and immovable and movable property, we're coming back to why that is relevant here. So the definition of property in the PRA is very broad, and it includes, as I said, real property, personal property, estates or interests in property, debts and other rights or interests. And if a property owner is a person who is the beneficial owner, so you can have a beneficial interest in a piece of property, and that will still need to be quantified in the division of relationship property, which means that you can't, and this is part of the reason why that, so some of those trust busting provisions are relevant. You can't sort of move the property to someone else's legal ownership for the purposes of avoiding the relationship property legislation. You would need to make sure that you've got all the contracting out agreements and that it's been appropriately planned. The Clayton and Clayton case is considered to be very significant in that Mr. and Mrs. Clayton had a long-running dispute or litigation throughout various courts relating to the division of their relationship and trust property. And in this particular case, it was found that Mr. Clayton's powers and interest in a trust were classified as property. And then when looking at the other circumstances, the court went further and found that it was relationship property. And in those circumstances, Mr. Clayton had the power of appointment of trustees. He was a discretionary beneficiary, he was a trustee, etc. He basically could control the trust and essentially make sure that the trust made, distributions to him as discretionary beneficiary whenever he felt like it. And again, the Act applies to immovable property in New Zealand or movable property in New Zealand. So that's, basically the real property and chattels, etc. Or elsewhere if a partner is domiciled in New Zealand. So what that means is if someone, and they don't necessarily need to be a New Zealand citizen or resident, but they apply within New Zealand for the division of relationship property, and they meet the definition of domiciled, which we won't go into here, but I understand it's significantly similar to what domicile is under tax legislation. So I believe you'll cover that in section 2 of this course. Then they could actually apply to the courts for the division of relationship property and movable property elsewhere. However, the courts aren't necessarily going to make those orders if it's not practical, or they feel that the laws of another jurisdiction, make more sense. That is actually, so that's section 8 as it actually reads, as to all the kinds of property that are considered to be relationship property, so A to L, although F is repealed, but it's quite long and substantial. But if we look here, the summary essentially is you're looking at family home and family chattels, and chattels include, the furniture, household appliances, and motor vehicles, and pets whenever required. So again, that it doesn't matter, that whenever required is important. It doesn't matter when if that was acquired before or after the relationship began. All property owned jointly or in common in equal shares by the partners. All property owned by either partner or before the relationship, if the property was acquired in contemplation of the relationship and was intended for the common use or benefit of both partners. So, for example, if you buy a house or even a car that you intend that you will share, even if you haven't yet got married or even yet moved in together, then that property is going to be considered to be relationship property. All property acquired by either partner after the relationship began, that is subject to the exceptions relating to separate property and increase in value, etc., of separate property that we'll look at. And this is where things get interesting. The proportion of the value of any life insurance policies and superannuation scheme entitlements that are attributable to the relationship. What that means in principle, using, for example, a KiwiSaver, is if you started your KiwiSaver in 2003, you started a relationship in 2012, and you separated in 2020, then you're going to be looking at what was the value of the KiwiSaver in 2012, what was the relationship in 2020, how much of that increase in value is there. And you're going to be using sort of actuarial tables and getting an actuary to help you calculate how much, because you're looking at compound interest, etc., how much of the increase in value is directly proportional to the interest that is attributable to that 2012 to 2020 part of the relationship. And we'll look at this in detail, but there are ways to sort of get court orders to transfer interests in superannuation schemes and life insurance policies, which, for example, if you are working for some of the big like Defence Force or some of the more historic sort of government superannuation schemes, can be of quite significant value. And when a party may not necessarily have cash to pay in a relationship property settlement, so that superannuation scheme entitlements might be transferred from partner A to partner B with permission from the court. Any questions, comments? Okay, so family home is the dwelling house that either or both of the spouses use habitually or from time to time as the only or principal family residence. Now, we're talking about family homes that people are actually able to own and buy, which, considering the current property market and economic situation, means that a number of people aren't covered by this. The Property Relationships Act can make occupation orders to state that X should be able to remain in the rental property if you meet some quite high thresholds. But generally speaking, this is, assuming that the parties do have a family home, but it is meant to distinguish between, for those people who have maybe significant wealth, or in those situations where one party may bring in a house and when one partner may already own a house, the parties agree that that is going to become their family home, and then the other party sort of rents out their house. Then those two houses will have different classifications as to property. That doesn't necessarily mean that the home that is rented out does not become relationship property, or some of the income that is earned from that home does not become relationship property, but they still do have different statuses. And it doesn't matter whose name is on the title or how the sort of shares are divided. So, for example, even if you purchased a home together and said that one person was going to have a 3/10 share in the property and the other person was going to have a 7/10 share, if you become a qualifying relationship and you don't otherwise have, a contracting out agreement, the law is going to treat that as 50-50. Homesteads apply for farms, and it's a little like when you're sort of talking for finance and tax purposes about house and curtilage, and versus the rest of the farm. And you're looking at the family home where the dwelling house that comprises the family residence is situated, and that is wholly or principally used for the per household. So you sort of look at the overall farm, and then you find where the family home is located on that farm, and then you're going to be looking at the area surrounding that is used wholly or principally for the purposes of the household. And that, you know, might be the lawn, garages. It depends. It can be interesting how wide that can be. And farming and sort of relationship property can get quite complicated. Most large-scale family enterprises these days are structured in such a way that the land will often be held in trust anyway, or owned by a company, then that's with shares owned by the trust. It's very rare for farming properties or substantial farming properties to be held personally these days, from my understanding, but there would be important exceptions. Okay, chattels, furniture, appliances, effects, so basically all that stuff that you put in your house and that clutters up your house, as well as motor vehicles, etc., which are used wholly or principally for family purposes. That does distinguish it between, so if you, for example, are a self-employed contractor or, you know, electrician, etc., and you have your work tools and maybe a work van, etc., even if it's sort of parked up at the house, that is not going to become a family chattel. It may, for other reasons, become relationship property, but it's not a family chattel. And yeah, the pets. So pets are property, which can be interesting when trying to figure out who should get, you know, the dog, and whether or not, you know, there should be some compensation for X getting the dog or not, and what value the dog should be given. But the pets are actually just property under the legislation. Please sing out if you have any big questions, comments, etc.
Yeah, Michelle.
Mm-hmm.
So like in terms of like the household furniture and appliances,
yeah,
because like in case for like homes and shares, it's easy to be divided like according to their share, but how does it work for like household furnitures and appliances and stuff?
Generally speaking, what happens is they're given a value, and so the parties have to agree on a way that they are valued, and then they will be divided up. Often, of course, you know, people might just, you know, you take this, you take that, and it's not uncommon when the parties actually have to get a lawyer to help them with the division of relationship property, because there's like a family home and a mortgage and a bank to talk to. But otherwise, they'll often sort of have divided that up themselves, and they'll tell you that they're quite happy with that 50-50 share. Okay. It's still, however, not uncommon for when people might be locked out of the house because, you know, someone has discovered some terrible behavior of the other, and they might want a particular, you know, piece of furniture, etc., particularly if they need to furnish their own new house. Like, can I have the TV in the upstairs bedroom, please? But yeah, it all very much depends on how amicable the people are and how much they just want to get on with their lives. But it's not cut, they're not cut in half.
Yeah.
And so you know, often when people have more than one motor vehicle, you know, they'll divide those up, and there'll need to be some valuations of those.
Okay. So it's all based on like valuations, then after that you'll be divided like equally among them.
Yeah, and that's partly, you know, when I was talking about the fun of spreadsheets, and there's a slide, but we can mention it here. So essentially, when you're looking at the division of relationship property, you're looking at essentially the value at the date that the property gets divided up. And so that will mean for things like household furniture, appliances, etc. Sometimes you might even be going on Trade Me, etc., to see, you know, what those secondhand pieces of equipment will be at. You're not looking at their new value. Yeah, it's really remembering that, you know, lawyers' costs are upwards of $200 an hour, plus GST, and yet sometimes you can spend ages arguing about who gets a rug. And it's, you know, you could probably buy a new rug with the money you would save if you just didn't involve your lawyers in it. Okay, so relationship debts. The most common kinds of relationship debts you're going to be looking at are mortgages, or things like just sort of like cue cards, sort of loans, hire purchases for property, etc., although they can arise in other ways. For example, when you may be, acting together as a guarantor for a family business, when directors will often have to sign guarantees, and if that comes back to bite you and the relationship, and the business was considered to be relationship property, then that debt is going to be considered to be relationship property as well. You can't take the good with the bad without taking the bad, sorry. You have to, if you're going to claim something as relationship property, then you are going to have to be responsible for the debts that are associated with that as well. So this is just a short definition from the Law Commission, and it's a debt incurred for the common benefit of the partners or in the course of their common life together. So this will be, of course, distinguished from what I mentioned before of the gambling debts, where, that was clearly his own separate debt. There was no common benefit to that. Or, for example, if someone purchased from they got an inheritance, and they then used that inheritance as a deposit on getting a boat so that they could go just fishing with their mates, and they never took their partner with them, then that debt would be a separate debt. And essentially what happens is the net value of the relationship property to be divided is calculated by determining the total value of the relationship property, and then subtracting any relationship debts, which makes sense. So separate property is property acquired by either party while they were not living together as a couple, so prior to their relationship. It could also be, for example, now that we've got people who enter a number of relationships during their lifetime, it could be the property that they receive from a settlement or division of relationship property. So if you have relationship one ends and you get a house and a car from that, as well as maybe some payment from your partner, former partner, then that will become your separate property. And the question then becomes of how that then is applied when you enter a new relationship. But if you keep it separate, it's separate. Property acquired out of separate property, and the example here is dividends received from shares acquired before the relationship. And property acquired by a partner is an inheritance, a gift, or because the partner is a beneficiary under a trust. And we'll look at the issue with potential intermingling of that next, and then also property with a special character, such as heirlooms and taonga. And that could include, so that's where it might be carved out from the family chattels. So if you had a historic piano that your great grandparents brought to New Zealand from Germany, and it had been in your family for generations, and then your children learned to play the piano using that piano, it would still be considered, which would otherwise, mean that it had been used for the common use or benefit of the relationship. But because of its historic status and significance, it would be considered to be an heirloom. So yeah, again, all property acquired after a court order. So again, if you separate, that's going to be separate property once the court has said you take X and you take Y, but also from just an agreement between the parties as to who takes X and Y. However, if there is a division on the bankruptcy of a spouse or partner, and we'll look at protected interests, etc. next session, then if the parties are still together, so A goes bankrupt, but A and B are still together after that bankruptcy proceeding, then if they continue to accumulate property together after that bankruptcy proceeding, that is going to be relationship property, which makes sense. But this is where things become interesting. This is intermingling. So when separate property can become relationship property. And one can be when the increase in value in the separate property is due to the application of relationship property or the actions of the other partner. For example, and it's unlikely in this kind of housing market where the value is often in the land, but if the other partner had a second house and it was just used as a holiday house, but you used your joint savings together to improve or renovate that house, or if it was owned by A, but B would every now and then go to their weekends and renovate the property, then there might be, which would increase the value of the property overall, then there might be a relationship property quotient there. There would also be the case when separate property is used to acquire or improve relationship property, or it is mixed. So that's again intermingling. The most common example of that is often with inheritances. So if you get a $100,000 inheritance from your dad, if you put that in a separate bank account and you keep it separate, and every now and then you might use it to, purchase yourself a treat or a new boat, etc., that you just use, it's going to stay separate. But what's often done is that money will be used, for example, to pay off the mortgage of a property, a jointly owned property, etc., and that then becomes relationship property, and you can't really recover that $100,000 later when you're dividing up the relationship property and say that should be taken into account, unless of course you've got a nice written agreement that that's what's going to be the case, which is again why having contracting out agreements is important. It's also just keeping those things separate, a reason why if someone is going to get an inheritance or a distribution from a trust, etc., then they should be keeping those in separate bank accounts, because as soon as the money goes into sort of one common pool and bank account, it's often that's used for day-to-day expenses, it's going to become intermingled as well. And then just finally, so this is along the lines of what Victor we're talking about with Victor. So in terms of shares in relationship property, that is determined either at the date of the application in court if the relationship hasn't ended. Sometimes you might want a declaration of who wants what for the purposes of like creditors, etc. Or otherwise the date the relationship ended, which is again why you want to know and be able to fix those dates. And so remembering it's not always going to be equal shares. You're going to be looking, if it's a short duration, on contribution, but also if you're looking at that superannuation policy increase, etc., you need to be able to fix, from what date to what date you're going to be calculating it as, or if you have contributed somehow to the increase of the value of separate property, you're not necessarily going to be getting, like if the house was worth $600,000 before you put some work in, and now it's worth $900,000, and you can say that's attributable to your work, you're usually going to be talking that difference between the 6 and the 900,000 as in 150,000 or so. You're not going to say it's the entire value of the house. So that is why determining shares can be important. And again, the value is determined as the date of the hearing of the court application. And so that's going to be quite important, for example, because it could take some time for the matter to go before court and to be heard, or if you're actually settling, it via agreement, it provides to some extent no incentive, it could provide either incentive or disincentive for the parties to delay settlement, because the property may or may not be decreasing or increasing in value since the separation, and that in terms of the housing market, that could be quite important. So if you were, and I see the time's not in soon, if you were, for example, wanting to buy your partner out so that you could stay in the house, then you might want to settle sooner rather than later if you felt that the property market was going to continue to increase, because you're going to have to often borrow to get that money and also pay out your partner. But the person who's not going to, who's going to be paid out might have an incentive to delay it. That's it for relationship property for now. As I said, the next session will look at contracting out, some exceptions that apply to the 50-50 division, and what else? And the changes proposed to by the Law Commission. But does anyone else have any questions or comments? No, okay, I will leave the recording here, and I'll see you for my final session on Thursday.
Oh yeah, Michelle, sorry. Just like a bit of a question for the assignment.
Mm-hmm. Do you want this to be recorded?
Yeah, sure.
Yeah.
Yeah, so for the assignment, I know you said that there's no specific format to it.
Yeah.
But like what I'm doing, I'm not sure whether it's right or wrong. But the first part is the overview of the like the key facts.
Mm-hmm.
Then the second part is the relevant laws to the key issues.
Mm-hmm.
Then after that will be like my justification for the laws that I've used. Then the end part will be, I'm not too sure what to put for the end part.
Just any comments maybe as to further actions or questions or more information that's needed, etc.
Okay, so what I'm doing, is it like on the right track?
And there are multiple ways of doing it, but yeah, if you use the suggested sort of things you need to address in the instructions, and also use the marking guide, and just think, could someone who's reading it identify, you know, these relevant points, then it's fine. It's just keep in mind the audience, who's going to be reading it, the circumstances in which they're going to be reading it, etc. But as I've made clear, or as I've commented in some of the forum posts, I completely understand that because there is no example, that can make things a bit difficult. So I'm not going to be, you know, I'm going to be marking with that in mind. And also the format is relative, you know, is worth a relatively low number of marks.
Okay. And like in the requirements as well, you say like it has to be like around 3 pages, and it's 1,000 words excluding references. So
it's not a target.
Okay.
So if you've only got 300 words, you're probably worrying. If you've got like 1,500 words, you've gone way too above. But the 1,000 words it's just a guide about the level of detail that's looking at. So it should be thereabouts around 1,000 words. But if you think you can do it, for example, on, I don't know, 800, I'm not going to be too worried.
Okay. But that's including the references, or
that's excluding references. Okay.
And I saw like in the forum as well, you said like we don't have to cite fully like the case name.
So what you do, so for example, if we go back to, so I haven't cited too many cases yet, but if you were, and you won't be because this is not a relationship property, there's no relationship property question. But if you said, for example, in the case of Clayton and Clayton, and you might put that in your body, but you could footnote it or have it in your reference with the remaining details. So the remaining details should be able to be found somewhere on your paper, but you don't have to, you know, put them in the body.
Okay.
That makes sense.
Okay.
Yeah.
So I'll just put like in the body, I'll just put like in the case of Clayton versus Clayton, then I'll put my justification, then that'll be fine.
Yeah, as long as somewhere in your reference, however you choose to do that, you do show which, the 2016, etc. Because, for example, if the Clayton and Clayton, there are a number of Clayton and Clayton cases.
Okay.
So you need to know which one's which.
Okay. Then in like the reference list, I'll put like the full details like of the case and everything.
There's no one way of doing it. Otherwise, you could use footnotes or whatever.
Okay.
Yeah.
Okay. Yep. There'll be all, I think. Yeah.
Anyone else have any other questions relating to the assessment? No. Okay. I will end here.